Good evening, everyone. My name is Monique Harden, and I'm co-director of Advocates for Environmental Human Rights in New Orleans, Louisiana. And I can tell you that our work is often coming after the house is on fire. Community calling because of pollution issues, toxic exposure problems, can you help? And this is one of the rare cases where we are at a place where prevention and precaution, we had that opportunity for that. With regards to this application, I see it's a real test for not just the department here, but for the entire state in terms of what do we say no to with regards to industrial operations? What is sacred? What is beyond the limits? And what's being proposed is like the camel's nose under the tent. And we think we can just make sure that nothing more than that nose of the camel will be under the tent. And Louisiana is a living proof that we cannot prevent more than the nose from getting under the tent. We have a shrinking, rapidly shrinking state. Communities like mine in New Orleans and south of us are in danger of maybe not being in existence in the next 50 years because of largely due to oil and gas operations in the coast and in the Gulf. With that in mind, I just wanted to focus in on the responsibility of the department under the Louisiana Constitution, Article 9. And it's one provision in the state laws that we have that gets the closest towards protecting a human right to a healthy and safe environment. Article 9 of the Louisiana Constitution reads as follows: the natural resources of the state, including air and water, and the healthful, scenic, historic, and aesthetic quality of the environment shall be protected, conserved, and replenished insofar as possible and consistent with the health, safety, and welfare of the people. So that's your charge, is how are you going to follow that and ensure that that constitutional guarantee for all of us in this state with regards to this application. One area that is missed is the permit application and what you all require for a permit application. The Louisiana Supreme Court has interpreted Article 9 of the Constitution as requiring at the very least a weighing of pros and cons with regards to activity that would negatively affect our air, water, land, health. And with regards to that, there are these, and you've heard in the comments before, an assessment of that pros and cons of an application that comes through is what's known commonly as the IT questions. Some of the questions that this gentleman here began with and have been asked by others are the kinds of questions that are required by IT questions in pursuant to this constitutional provision. It should be part of the application process. And but it's not, and I think that's one of the ways in which the department needs to take another step towards fulfilling its constitutional duty here. With regards to what we do have with the permit application, I have to say that I learned more from the PowerPoint presentation here than I did in the permit. So you guys haven't been served with whoever did this for you all. I've heard more in the comments that your statements than what's provided here in the comments. Then there have been statements that have conflicted with what's within the permit application. So that creates a whole lot of area around, well, what are you really asking for? What will those effects be? Specifically, with regards to the time frame for the water withdrawal from the Amite, through tonight's presentation, we learned that it's all conditioned on the level of pond water. If the level of pond water is at so much with regards to amount of water, there's no need to withdraw from the Amite River. Am I correct in that understanding?
Correct.
Okay. There's nothing in the permit application that lays out that condition. And so there should be some sort of necessity purpose statement, but also laying out that this may not be necessitated given where we find ourselves with regards to pond water levels. That's number one. Number two, that also then means that we need to get clarity on the time period for this application. In the application itself, it says 2.3 to 8.6 days if it was done on a continuous basis or stretched longer than that. That is way too vague. There should be a start time and a permit expiration time with regards to this operation. Again, understanding the relationship of the river withdrawal as a backup plan for drawing from the pond needs to be identified and assessed and presented clearly in the application. It would be interesting to know what considerations have went into the selection of the winter of 2015 as the period for the withdrawal. Is it just due to, projected rainfall periods, or if there's some other conditions that needs to be identified and presented in the permit application? The other thing I wanted to just quickly, sorry, we have to go through this just a little bit. Yeah, with regards to the pond in the conversation that we've had tonight, you all laid out that it's the rainfall recharging the pond that is critical to the needs that you all have for the fracking operation. However, the focus is on the rainfall replenishing the Amite River. And that's on page 7, where it says the Amite River will naturally recharge over time from rainfall in springs, but there's no conversation, no discussion with regards to rainfall or pond levels or the fact that the pond is the primary source and not the river. And then with regards to the requirements that are within the section 117 of permitted activities in the Louisiana regs for this kind of a permit for scenic rivers, we don't have a full description of the project. And I think that's extremely important because this project is not limited to the withdrawal of water from the Amite River. That's a part of a project for fracking. And I think that whole project needs to be laid out in the permit application. Why? Because it would give an indication of what the realistic assessment of water withdrawals. Studies that have been done on fracking have shown that the production of oil and gas through hydraulic fracturing or fracking have required anywhere from 1 to 3 million gallons of water for 1,000 cubic meters of gas, for example. So exactly how much, what's the fracking operation about, how much gas or oil would be produced would give us an indication of what realistic assessments could be made about water levels. And under section 117, how does this go? 117 C5, that's required, a full description of any portion of the project which is under development or is completed. Again, we don't have subsection 10 of that same section that requires an identification of all permits applied for or obtained for all state agencies for any portion of these any aspect of this project, as well as your compliance history or regulatory responsibilities elsewhere in the state. And then with regards to the project evaluation, there's a list of things that should be required, but this list is not limited. And I think this is the area where the IT questions and assessment can come in, is under that section F, under the subsection F under section 117. And that's it. Thank you.
Thank you.